Hi guys, it's Kathy. I hope you're doing well. I I'm gonna work on getting my intro video started today, but it won't happen during OJ anyway, so doesn't matter. All right, we are on May 12th, not May 10th, like the title says. I'm gonna fix that. Don't worry. Don't worry. Here we go. Let's press play. Oh, we're at the very, very, very end. I stopped it when there was only 4 seconds left in the video yesterday. I didn't even realize. Let's make sure the speed is correct. The speed is correct. All right. Now it's going to move to the next video. That's their sounding echoey. I don't know why it sounds echoey right now, but that's them.
All right, Mr. Neufeld, which photograph? These are both side by side?
Yes.
All right. You showed to the witness as to each one of these 1146 and 1147 a group of 3 photographs.
Yes, but
Oh, that's really bad.
one photograph is simply the external envelope. I didn't
Right.
feel the need to show that.
All right, you're just offering. Are you offering those as a group of 3 or just these 2 photographs?
Just these two
All
photographs.
right, proceed.
Okay.
Let me
Thank you.
try something.
Now-
Get
Hold
that
on.
focused a little better. All right, Mr. Neufeld.
Now, now you obviously know what the markings are on these different photographs, Dr. Cotton, or you may know. But just from looking at those photographs, for instance, swatches came from item 12.
No.
And would it be fair to say that as you look at the swatches that purport to be item 47 and purport to be item 12, that you can tell which ones are very degraded and which ones aren't?
That's right.
And in fact, Dr. Cotton, I believe you said that, well, let the record reflect that the upper photograph represents the swatches from item 47, that purport to be item 47.
1146.
Right. And that the lower group of swatches in this picture, which would be 1147,
7.
purport to be the swatches from item number 12. And based on your testimony, you would agree that there is a lot more DNA present in the swatches from item 12, which is the bottom photograph, than there is in item 47, represented by the top photograph.
Objection back. Overruled.
Yes, that's correct. Well, the DNA is in better condition in item 47 than item 12. I haven't I'd probably have to go back and think about a comparison for the precise amounts of DNA.
Well, Dr. Cotton, in fact, you said one of the ways that you assess the precise amount or approximate the amount is through a slot blot, correct?
Yes, did I just say that backwards? It's item 12 is in better condition than item 47.
Okay.
Sorry.
One of the ways-
Yes,
one-
backwards.
One of the ways that you determine the quantity of DNA, of human DNA that's present, is through a slot blot, correct?
Yes,
And did you do a slot blot on both item 12 and item 47?
probably.
Could you check your notes and please tell us what result you obtained for item 12?
Yes, it'll take me a minute.
Please do.
Going to break at 10:30.
Break at 10:30?
10:30.
Are you asking me how, okay, oh, I'm sorry.
Is it me or is it a little warm in here? All right, apparently the DWP our power department here, had a power surge, which is what that glitch was. Apparently our air conditioning system went down with that. I'm having Mrs. Robertson check, so if you want to stand up and take your jacket off, be my guest. All right, let's proceed. I thought it was just me.
I don't know what would give you that idea, Your Honor. By the way, may we mark this printout as defendant's 1148?
Yeah,
Thank you.
side by side, yes.
Yeah.
1148.
Have you had a chance to look at the slot blot for item 12?
Yes, I have.
And by the way, does that slot blot represent 10% of the whole sample, or is it again 10% of the portion that was set aside for PCR testing, which is approximately 10% of the whole sample? Or if it's something completely different than both of those, please explain what it represents.
The slot blot is giving us information about the DNA in the 10% of the sample that was set aside for PCR testing.
But the portion that you used in the slot blot, is it 10%? Is it a 10% solution of that 10%?
That's right.
So really then, the slot blot is approximately 1% of the entire sample. Approximately, is that right?
Yes.
Okay. Now, what was the slot blot reading you got for the amount of human DNA present in item 12?
For the amount that was loaded on the slot blot, my estimation is there's approximately 0.5 nanograms.
So now, did you also do a slot blot for item 47?
Yes.
And could you please tell the jury what you came up with for the slot blot on item 47?
Yes, I have to take the same time to do that. Okay.
Okay. Isn't it a fact, Dr. Cotton, that for item 47, when you ran that slot blot, the amount of DNA observed was 0?
That's what the slot blot's saying, yes.
Thank you. Yet,
It doesn't
notwithstanding,
mean that there's none there. It means that this measure can't detect any.
did you conduct any other test to assess quantitatively the amount of human DNA present in the sample?
In 47?
Yes.
No.
And would you agree that notwithstanding the disparity between the 0.5 and 0, those differences would not be observed when you look at these swatches before they're tested?
Yes, that's right.
Do you have the sample? Now, in a hypothetical that Mr. Clark gave you on direct examination, he talked about... Is that that? He talked about... He asked you to assume that item 47 was a blood stain found in an area that had soil and leaves in it. Do you recall that?
Objection, Ms. Stacy Evans.
Overruled.
Do you recall that?
I'm sorry, ma'am, being heard on the show.
Do you have the transcript site?
I do not have the transcript, site, Your Honor. That is my recollection. If you want to take the recess now, I could find that citation during the recess.
All right, let's do that. All right, ladies and gentlemen, I'm going to take our morning recess at this time. Please remember all my admonitions to you. Don't discuss the case amongst yourselves. Form any opinions about the case. Don't allow anybody to communicate with you. Do not conduct any deliberations until the matter has been submitted to you. And we'll see you back in about 15 minutes. All right? All right, Dr. Cotton, you can step down. apparently when that power surge hit the county's power plant, there's a computer that immediately shuts the equipment down in the event of a power surge. And there's a startup procedure that has to be gone through. And for those of you familiar with our power plant, we have some rather large turbines over there that have to be started up again, so that's what's happened. So hopefully we can survive the rest of the morning. I'm told it's back online manually, so we'll start cooling slowly, but since it's a short day, we'll just slog through it. All right, Dr. Cotton. Good morning again, and Mr. Neufeld, you may continue with your cross-examination.
Dr. Cotton, good morning, still. Hi. Dr. Cotton, I've just shown you those two photographs comparing the swatches from item 47 and item 12. Do you recall that?
Yes.
Okay. Now what I'd like you to do is to show you a computer graphic that was created, and I want to ask you some questions about it, Dr. Cotton. And this, Your Honor, this will be defendants 1149 A through L.
What happened to 1148?
1148 was a printout
Right.
of the side-by-side.
Oh, I already have one. Yeah, you can take that one.
I don't know if it's easier for you to look up or down, Dr. Cotton.
I don't know, I'd rather come down here and look if that's
Whichever is your pleasure, ma'am.
allowable.
Fine. Just so long as the court reporter and the jury can hear.
Dr. Cotton, what I'd like you to do for the purposes of this demonstration of visualization is assume that that red rectangle is a swatch, a bloodstained swatch. Now, obviously, a bloodstained swatch is much smaller than that, right, Dr. Cotton? As collected in a crime scene.
Yes.
And certainly the ones in this case are a heck of a lot smaller, aren't they?
Yes.
Okie doke. And in the illustration, Dr. Cotton, this is a blood swatch representing the blood stain on it coming from person 1. And on that blood swatch, I have placed the number 1 4 times to suggest a certain quantity, whatever it is, of DNA present in that swatch.
Okay.
Okay? And now, could you please show B? Now, would you agree, Dr. Cotton, that sealing that swatch in a plastic bag, if it is moist, if the swatch itself is still wet, can cause degradation of the DNA?
Over time, degradation will occur.
And that, okay, and putting it in a plastic bag as opposed to a paper bag, for instance, enhances that degradation. Isn't that correct?
I don't think that, again, for the short term, it's going to make any difference. For a longer term, it would.
And when you say it would make a difference whether it's packaged in a plastic bag as opposed to, say, a brown paper bag.
Yes.
Okay. Could you please show the next one? And if you added to that plastic bag the factor of heat, the element of heat, would that even further enhance the degradation?
Probably would, yes.
Okay? Could you now add the next one? And again, just to reiterate, I think what you've already said, that as long as the blood swatch remains moist, that degradation will continue. Is that correct?
Yes.
Okay. Could you do the next one, please?
Object at this point is foundation and relevance. Assuming facts, not an evidence. Over.
And I think finally, the last element that you talked about before was the factor called time. And the longer the blood swatch is wet, and remains in that plastic bag and subjected to heat and moisture, the more it will degrade.
Yes, that's probably going to be the case.
Okay. Now,
Excuse me, Your Honor. You can enter another objection under 352 as to misleading. As far as the graphics are what I'm referring to.
All right. Were these shown to you previously?
Yes.
Overruled.
and you said, Dr. Cotton, I believe yesterday, that it is possible that the DNA can become so degraded in the swatch that although the swatch still appears red, it will have no identifiable DNA in it, or human DNA in it. Is that correct? That's possible.
Over a very long period of in order for it to not have, you won't get to the point where you don't have small bits of DNA, but you can get to the point where the degradation is so substantial that you can't easily measure it by the methods that are generally used in a forensic laboratory.
So what we're really talking about is the DNA's detectability. That's what's lost through time, moisture, heat.
Yes.
Okay. Could you please put that one? Now take that blood swatch, which has now been completely degraded, and assume for a moment that it is cross-contaminated with another. What's it? One moment. Now, assume that the degradation was so complete, as you just described it, that the DNA was no longer detectable. Please show the next slide. If you ran a DNA test on it, under those circumstances, you would get, I believe you said, no result. Is that correct?
Objection assumes facts not known.
Overruled.
Depending on the level of degradation, it can be so degraded that you don't get an RFLP result. And if the level of degradation can become so much that you won't get even a PCR result.
Now, one moment. Please put up 14N, please. Now, if you take that blood swatch, originally that came from person 1, and you brought it into actual contact with a wet blood swatch from person 2, or with fresh blood from person 2, could that cause cross-contamination as to the blood swatch that originally had the sample from person 1?
Objection improper. Hypothetical assumes facts not in evidence.
Overruled.
If the hypothetical is as you're suggesting, where you have a blood swatch and it no longer has typable DNA from person 1, and somehow it comes into contact with a second swatch that's wet in such a way that they are so closely connected as to transfer a sufficient amount of DNA to be typed, or a liquid blood sample, and same thing, you have to transfer a sufficient amount of DNA to be typed, then of course your hypothetical would be correct.
And by the way, Dr. Cotton, I think you said, for instance, in sample 52, there was approximately 25 nanograms of DNA present in that for that DNA test. Is that right?
What I said about sample 52 was, are you asking me about the RFLP result or the PCR result?
I asked you about the RFLP result to estimate approximately how much DNA was loaded in the lane. Wasn't your initial testimony that there was approximately 25 nanograms of DNA in that lane?
That is correct, and that is what I said yesterday. What I said yesterday, however, wasn't completely precise, and I can clarify it if you wish me to.
Go ahead and clarify that, please, Dr. Cotton.
When I made an estimation that there was 25 to 50 nanograms of DNA for the RFLP result, what I was doing in my head was saying, if I compared, and these things have been done in the lab, so I have some mental image of this. If I took a known sample of specific quantities of DNA that was in good condition and I loaded different amounts on a gel, the intensity of the banding pattern that I'm seeing from item 52 is about the same as I might expect to see for 25 to 50 nanograms. Now, if you look at the DNA in item 52 on the small gel as it was originally on the mini gel to see how degraded it was, you see that there's DNA all the way from the top of the gel all the way on down, meaning it's quite degraded. Only the big pieces of DNA.
Keep your voice up, please.
Yes, only the big pieces of DNA out of that sample can participate in the RFLP pattern. So whereas it's clear that there's mass-wise, that is total quantity, from the slot block there's more than 25 or 50 nanograms, what I was telling you was that the pattern...
Actually, she can return to the witness stand for this.
All right.
Would you please? Thank you, Dr. Cotton.
What I was telling you was that the pattern was the equivalent
of 25 or 50 nanograms of DNA that's in good condition. So more DNA existed in that whole sample, but the amount that could be participating in the RFLP had to be that portion that was in good enough condition, and that would have been some much smaller portion than the whole sample.
And Dr. Cotton, when you described that, was it a yield gel where the DNA is spread out along the whole length of it?
Yes.
On the yield gel test, and correct me if I'm mistaken, you will not be able to distinguish bacterial DNA that is present from human DNA. Is that correct?
That's also correct.
Okay. Now, getting back then to the illustration in this particular slide, if sufficient quantity of either fresh blood from a reference sample or...
Excuse me, counsel. This is the fourth time we're asking this question.
Okay, I'll move on to the next slide.
All right.
Could you move on to... I. Now, in this example that I put up there, slide I, you have a situation where the initial swatch has now been cross-contaminated with biological material from person number 2. Do you see that?
Yes, you have 3 twos up there.
Right. And that's the 3 twos is simply to indicate that much more of person 2's DNA is on that swatch than person 1's,
Okay.
due to the combined factors of degradation followed by cross-contamination. Okay?
Okay.
Next slide is Jay. Jay, please. Now, if under this hypothetical, if you were then to do a DNA test, for instance, an RFLP test on a swatch that went through this process, wouldn't the RFLP test give you a profile for person 2 rather than person 1?
Yes.
And if the degradation was sufficiently complete as to person 1, wouldn't it also give you a PCR result for person 2 as opposed to person 1?
If the degradation was extremely extensive, yes.
Thank you. Now, one of the things I believe you said on direct examination, Dr. Cotton, was that the presence of soil and leaves mixing with a blood stain can cause degradation. Is that correct?
Yes.
First of all, let's put the boards.
This is People's Exhibit.
165, Your Honor.
Thank you, counsel.
And Dr. Cotton, would you come down and take a quick look at what is known as item 47, which is photo ID number 112? You see it?
Yes.
Okay. Do you see any leaves on that blood stain?
No, not that I can see.
Do you see any deposits of soil on that blood stain?
I don't see any big pieces of anything on the bloodstain.
Okay. Do you see, with your naked eye, any small pieces of anything on the blood stain?
Not that I can see in the picture, no.
Okay. And actually, as to, all right, you can have your seat again. Thank you.
Mr. Neufeld, I would suggest that you and Mr. Scheck show the graphic to all the jurors so they can see the close-up of that item.
Thank you.
I remember yesterday talking about it, saying she should stab him with it, but, or maybe I just said that in my head, I don't remember. I think I said it out loud.
Dr. Cotton, you mentioned on direct examination that one way to assess if there's going to be any interference with the DNA typing is to do what's called a substrate control. Is that correct?
Objection, Bay.
Oh,
I wouldn't use the term interference. It only tells you whether or not there was any DNA close to where the stain was taken from.
Well, doesn't the substrate control also tell you something about the nature of the substrate?
Spag, what's your rephrase it?
Do you know what is meant by the term substrate, Dr. Cotton?
Whatever the stain is deposited on.
And so the term substrate control refers to taking a control swatch, wet swatch, of the actual material that the stain is on. Isn't that right?
Yes.
And one piece of information that substrate control can give you as an examiner is to tell you something about the condition of the substrate, whether or not there are other chemicals present, for instance.
It doesn't, you're not testing for any other chemicals. The only thing you're testing for is the presence of human DNA, and the only way you detect that is if you have a type. So the only thing, for purposes of DNA, the only thing that substrate control is telling you is whether you had any other human DNA in a position where the substrate control was taken adjacent to the stain.
Dr. Cotton, through Mr. Clark's hypothetical, asking whether or not certain samples could be degraded as a result of their contact with soil and leaf stains or leaf material. What I'm asking you is, if the substrate control is taken right next to the blood stain, could that be a useful indication or provider of information to see whether or not the swatch right next to the stain has soil on it or leaf stains? Would that be something that you could look at?
Wait,
Well,
you could look at it with your eyes, and you could say, well, it's green or it's brown or whatever, but that's not any kind of scientific procedure to tell you what was on that substrate and then been transferred to the substrate control. You'd have to do some other kind of test.
So there is testing that could be done to determine whether or not there is soil present on that control?
I have no idea. That's outside my area of knowledge.
Now, I think you also said that soil itself can cause degradation, correct?
Well, the presumption is it's the bacteria in the soil that's causing the degradation.
So if these stains were brought into contact not only with a sealed plastic bag and heat and moisture over a period of time, but also soil, the combined effect of all of those different factors can further enhance degradation than if there was no soil present.
Yes.
And Dr. Cotton, has there been any research done as to whether or not soil can inhibit the analyst's ability to detect DNA in a specimen, in a biological specimen?
As far as I know, it's not going to inhibit your ability to detect it in terms of, for example, like a slot blot. You could say, it's here. It might inhibit your ability to type it if there's a lot of degradation.
So you're saying that soil only will degrade DNA, but it doesn't have this independent effect, namely of simply inhibiting the ability to type it?
No, I said it might inhibit your ability to type it, but it wouldn't necessarily inhibit your ability to detect it.
Now, there's already been testimony in this case, Dr. Cotton, about the amount of blood in the blood vial containing Mr. Simpson's reference sample. I wish to ask you a hypothetical question. If 1.5 milliliters of Mr. Simpson's reference sample was unaccounted for in that vial, approximately how many microliters of blood would that be able to produce?
Objection assumes fact not known.
overruled.
Also going still.
Sustained.
You talked on direct examination, Dr. Cotton, about the special sensitivity of DNA typing. Do you recall that?
I recall talking about issues of what tests were more sensitive than what other tests.
And you also talked about some of the safeguards that are necessary because of the particular sensitivity of PCR amplification. Do you recall that?
Yes, I do.
And would you agree that given the exquisite sensitivity of PCR amplification, it is essential that even greater safeguards be taken to avoid contaminating evidence collected than would ordinarily be used?
Why don't you rephrase that question? The concern is that the term exquisite is without definition at this
All
point.
right. Have you ever heard the term exquisite sensitivity applied to PCR amplification?
I don't know that I've heard that particular term. Exquisite isn't something you would normally see in the scientific nomenclature.
Well, how about extraordinary sensitivity? Would that be more appropriate to describe what happens to PCR amplification?
It's very sensitive. To me, it doesn't seem extraordinary given what we know about how well the reaction works. But if you compare it to other tests, then it is much more sensitive than other types of tests.
And as a result of that much, much greater sensitivity, would you agree that it's essential to have even greater safeguards to prevent any kind of cross-contamination of the evidence collected?
Objection vague.
Sustained. Rephrase the question.
Would you agree that special safeguards have to be taken in collecting biological specimens to avoid cross-contamination given the heightened and extreme sensitivity of the PCR amplification test?
Objection beyond scope.
Overruled. Doctor, do you understand the question?
Is he asking me whether or not...
Well, let me
I
ask you
don't
this.
know
Let me
much
ask you
about
this.
how evidence is collected at a scene, so I'm having trouble with the question.
All right.
Even without knowing how it's collected at a scene, but knowing how sensitive PCR typing is, and based on your expertise as a molecular biologist and as a forensic scientist, would you agree that special safeguards have to be taken in the collection and preservation of biological specimens that are intended to be subjected to PCR amplification?
Objection beyond scope.
Overruled.
When you use the term special, when the evidence is collected, and it should be handled in a way to minimize contamination. When you say, should you take special safeguards, I would expect that the same safeguards would be applied whether you were doing serology or RFLP or PCR. You don't want contamination between samples, regardless of what kind of testing that you're using.
In your laboratory, Dr. Cotton, isn't it true that over and above the safeguards and controls that you use for RFLP testing, you have additional safeguards for PCR testing?
Objection asked and answered.
Overruled.
Yes, that's true, but many of those safeguards are now because in the laboratory there is the existence of amplified product, and therefore, which isn't going to be out where evidence is collected. So many of those extra safeguards are designed so that you cannot get amplified product back to your original sample. Now, that's not 100% of them, but that's a good part of them.
And by the way, in your laboratory, to avoid the possibility of getting that amplified product back to the original location, I believe you said that you have a series of different rooms that the item of evidence moves through, and it's a one-way street. Is that correct?
Yes.
Do you have any knowledge, Dr. Cotton, as to whether or not the Los Angeles Police Department laboratory
Sustained.
The PCR amplification test that you utilize doesn't have the capacity to discriminate whether it's amplifying the original target DNA or a subsequent cross-contaminant. Isn't that correct?
That's correct.
And since it doesn't have that capacity, Dr. Cotton, would you agree that even a minute contaminant could be amplified perhaps 1 million times or more during the amplification process?
Objection asked and answered.
Sustained.
Well, as a scientist, Dr. Cotton, have you ever heard the expression, garbage in, garbage out?
Objection argumentative.
Sustained. Sustained. And I think as lay people, we've all heard the expression too.
Hope so. Well, in your laboratory, have you been taught and have you taught others that while working with a blood stain, one shouldn't do anything which could leave even a minute portion of the stain on your clothing so as to risk cross-contamination?
Yes, we generally try not to get the blood stains on our clothing.
And does your laboratory, in fact, have a written manual to spell
I
out the
have to.
safeguards that must be
Dumbass.
followed to reduce the chances of cross-contamination in your laboratory?
Yes, those procedures that are designed to reduce cross-contamination are laid out in the standard operating procedure.
And is everyone in the laboratory who handles biological material required to be familiar with those written safeguards?
Everyone in the laboratory who handles evidence is required to be aware and follow those safeguards.
Thank you. And these safeguards are mandatory, are they not?
In terms of our laboratory,
They're not simply suggestions.
Objection has an answer.
Well, but you need to allow her to finish answering the question.
in terms of our laboratory, they are mandatory. We're not just saying, we hope you'll do a particular thing. We're saying, we will all do this particular thing.
Now, in this case, there's been testimony by Gregory Matheson that the criminalists at the Los Angeles Police Department are not required to change their gloves in between the handling of each piece of evidence.
Sustain.
Objection.
Sustain.
Can we have a sidebar, please?
Nope. She's testifying about the testing that was done at Cellmark.
As in,
And you've already, she has no idea about the handling, packaging, collection of the evidence. We've established that. Let's move on.
may I ask questions that occur at the laboratory as opposed to at the crime scene? And ask her opinion as an expert.
It's irrelevant.
Okay. At Cellmark Diagnostics Laboratory, Dr. Cotton, is glove changing between each item required to avoid any kind of cross-contamination?
Can you be, what do you mean between each item?
Well, if a molecular biologist at Cellmark handles one item of evidence, let's say 47, for instance, in our case, and does some manipulation with the item using different pieces of equipment, and then packs up that item, and now takes out a second item of evidence, is the molecular biologist at Cellmark required to change his or her gloves before moving on to the next item?
They're not required to, and they normally, if they haven't touched the item with their gloves, that is, if they've handled it with forceps or a scalpel or something and they haven't touched it, then they may not change their gloves in between handling the first item and the second item.
Referring you have a protocol, you said, that has been prepared by Cellmark for the use of all personnel that handles biological items of evidence in the laboratory. Is that correct?
Yes?
Dr. Cotton, and there's a section in your written protocol dealing with the handling of evidence during preparation for analysis. Isn't that correct?
Yes, there is.
Isn't it a fact, Dr. Cotton, that in that protocol it states, quote, clean, disposable...
Okay, sir. All right. Let's say they don't. Let's say she's right, and they don't change their gloves after touching every piece of evidence. Okay, logically that sounds like maybe they should, right? But technically, if that caused a problem, it would cause a problem in every single murder scene. You know what I mean? Like, there would be cross-contamination for all of the results, in all of the cases, in all of the murder scenes. So there isn't like cross-contamination because of the laboratory. Could it happen? Yeah, I guess it could happen. But if it was a problem, if this was like you can't rely on their stuff anymore, then it would be like that all of the time. Just like he's talking about the blood degrading. If the blood was that fragile as he thinks it is, we would never be able to collect blood at a murder scene because it's exposed to the air. It's touching a leaf. We would never be able to solve any murders if how he thinks of DNA is even remotely true.
Gloves must be worn when handling evidence samples. To avoid cross-contamination of evidence, gloves are changed between samples. Close quote.
May I see it, please?
Certainly.
Yes.
Did I accurately read from your protocol?
Yes, you did.
Now, a moment. At Cellmark, are the scientists instructed in writing to change the bench paper that is used in manipulating samples in between the handling of each sample?
Yes. Excuse me, my voice is getting a little rough. Go ahead.
And at Cellmark, Dr. Cotton, when your technicians or molecular biologists, your scientists, excuse me, when your scientists manipulate the items with pieces of equipment, isn't it required that they either dispose of the equipment between items or put it into a beaker of bleach?
They will either dispose of it if it's a disposable piece of equipment, or they will clean it with bleach or alcohol.
And would you agree, Dr. Cotton, that bleach is very effective at instantly degrading DNA, that is, in breaking it down?
Yes.
And that's the reason why your laboratory uses bleach, is it not?
Yes.
And would you agree, Dr. Cotton, that simply wiping a piece of equipment with a chem wipe or distilled water will not be as effective as either disposing of the equipment or dropping it into a beaker of bleach?
Objection, vague, also beyond the scope.
Overruled.
I would prefer wiping it down with bleach or alcohol as opposed to wiping it down with water. Wiping it down with water is better than not wiping it down at all.
Well, granted, but you would agree, Dr. Cotton, that if you're really concerned with getting rid of any lingering DNA or biological material that may be invisible to the naked eye on the piece of equipment, bleach is a far better tool for doing that than simple distilled water.
Well, remember, at that point, you don't have naked DNA. I mean, you've still got cells there. And the bleach has to get to the DNA in order to destroy it. So it may be just as effective or may not. I don't really know.
Do you know anything at all, Dr. Cotton, about whether or not water alone will kill and degrade DNA?
No, it won't.
Okay. Another point that you made, Dr. Cotton, I believe on direct examination, is that it is important not to rush these tests. Is that correct?
Objection, vague.
Overruled.
I don't think I said a thing about rushing the tests.
Well, I think you said to Mr. Clark that if you had no other cases going on in the laboratory and you were conducting a PCR test from beginning to end, in other words, from the moment you receive the samples from an outside law enforcement agency until you get the dots on the strips, that you could get results in as little as a few days, I believe you said. And if it's not a few days, please correct me.
No, you could get well, if you worked a really long day, you could start one sample at the beginning and get results by the end.
What's a really long day? What time would you have to start to do that?
Well, it's, depends on what kind of DNA extraction you do. Some of them are shorter than others. So if you do a short one, and then you set up your amplification, so say your short one took an hour, your amplification setup takes a half hour. Your amplification takes about 2.5 hours, what is that, up to 4 or so. And then the typing itself takes about 2 more hours. So, and given that you're taking some pauses in between, if you worked all day, you could get, and you didn't have anything else to do, you could get a type. If you started in the morning, you could get a type by the end of the day.
How about if you were working with a dozen different items?
Well, then it would make your day longer.
But you could still do it in one day?
Yes.
Have you ever done PCR typing on evidence specimens in groups of a dozen that quickly in your laboratory, in actual casework?
I don't really know.
Now, you said that at Cellmark, I believe, the room where the evidence is handled, I think you referred to it as, quote, a biological safety cabinet, unquote. Was that the term you used?
No, what I said was that the DNA extraction is done in a biological safety cabinet, and it's not a room, it's a thing, it's a piece of equipment.
And it's called a biological safety cabinet?
Yeah, or a hood. Call it a hood.
And does that hood prevent airflow from outside the cabinet area from coming inside the cabinet area?
Yes, it does.
And what is the reason that you want to prevent air from outside the cabinet area coming inside the cabinet area where you're doing the extractions?
Well, in reality, it also prevents what's inside the cabinet from coming outside. And the first reason to use the cabinet is the protection of the analyst, because, as most of you probably know, blood samples can contain viruses that can be very harmful. So, first reason is to protect the analyst. Second reason is to protect the evidence.
When you say protect the evidence, you want to avoid, again, cross-contamination with this biological cabinet. Isn't that correct?
Yes, it's the area in which the DNA extraction is done. It's not the area, for example, if they may handle evidence outside on the bench. For example, they wouldn't handle a hair in the biological safety cabinet because the airflow is sufficient that you might blow it away. So you wouldn't want to do that.
Is what you're talking about, is it a laminar flow hood?
Yes, a laminar flow hood.
Thank you. Have you ever inspected the Los Angeles Police Department SID laboratory?
Counsel, sustained.
And in your laboratory, to avoid cross-contamination, do you do your extractions on evidence at a separate time and place than when you do your DNA extractions on a reference sample?
At a separate time, not a separate place.
And when you say a separate time, how much time is there separated between the extractions?
Well, it could be just a matter of minutes if you did one, put it away, and then got the other one out. Or it could be a matter of days or months, depending on when the various items were actually received.
And you keep the extraction of the reference sample separate from the other extractions until you get to the amplification stage.
That's right.
And why do you do that?
We did that, we set that up in response to the results that we got on the second group of CACLD proficiency tests, where we clearly had some contamination that we couldn't determine precisely where it came from.
Would it be fair to say that one danger of doing the extraction on the reference sample at the same time that you do the extraction on the various items of evidence is that you could get cross-contamination from the much more enriched DNA in the reference sample?
Yes, I think that's what I just said.
And as a result of that kind of cross-contamination from the more enriched reference sample, couldn't that lead to a false positive in the evidentiary
Dumbass.
specimens?
Objection, I think this is asked and answered.
Overruled.
Yes, it could.
Okay. Now, by the way, Dr. Cotton, under your own laboratory's procedures, would you extract samples from two different crime scenes at the same time as one another?
Objection beyond the scope.
Overruled.
Yes, we might.
If you were told by the submitting agency, Dr. Cotton, that samples from one location had much more DNA than samples from the other location, would that influence your decision to extract those samples separately?
Well, in general, the answer is no, but it's because people are asking us to do the DNA test. They're not ever telling us, you have this much DNA, so now go do your DNA test. Usually we're getting samples because the submitting agency doesn't have the same capabilities that we do.
Well, would you like to know, before you decide whether these samples should be extracted together or separately, whether some of the samples have much more blood on them than other samples?
Well, you might like to know that, but that's almost all the time not possible to know unless you're looking at the physical size. You have a stain that's a foot versus a stain that's an inch. Obviously, it's likely that the big one will have more than the little one, but and then you wouldn't use the whole big one anyway, you'd cut out a small piece. So.
Well, for instance,
I'm sorry, finish
Please.
your answer.
Yes.
So most of the time you simply can't know that because you can't know how much DNA there is on the stain just by looking at it.
for instance, in this case, Dr. Cotton, there's been testimony that when item 12 was collected from inside the foyer of Mr. Simpson's home, it was a collection of 3 drops of blood, as opposed to the stains at Bundy, which were taken from a single drop of blood. Is that a factor that you might wish to know or might consider in determining whether or not the extraction should be done at the same time or done separately?
No.
Just to go back one step for a moment, Dr. Cotton, you were mentioning the laminar flow hood that you have in the room where you do the extraction of DNA.
Yes?
Okay. Is the purpose of that laminar flow hood to create literally a wall of air which separates the rest of the room from that work area?
Yes.
It's not the purpose of a laminar flow hood to simply pull air from the lab into the work area and then outside, is it?
No.
Dr. Cotton, you said sometimes the submitting agency can't give you information about relative quantities of DNA because that's why they're submitting it to you for testing. Is that correct?
That's right.
But there have also been instances, have there not, Dr. Cotton, where the submitting agency itself has conducted DNA testing on the same items or some of the same items even before it is given to you. Isn't that correct?
That's right.
And do you know whether in this case LAPD had in fact conducted DNA testing on some of the same items that they gave to you before they sent them to you?
Objection, take this down. Items.
Oh, are you aware of that?
I'm vaguely aware that they may have done some testing. I don't have any information on what items, that I recall having anyway, on what items had been or hadn't been tested.
Well,
We did not
Sorry.
receive any DNA, extracted DNA, from LAPD.
Well, assume for the purpose of this hypothetical that the Los Angeles Police Department had in fact, as of June 14th, run PCR tests on every single one of the Bundy drops.
Okay.
As a result of that,
Objection, improper hypothetical.
Sustained.
assume hypothetically, for the purpose of this hypothetical, that the Los Angeles Police Department have run PCR testing on items 47, 48, 49, 50, and 52. Okay?
Okay.
Again, objection, improper hypothetical.
Sustained.
Dumbass.
Assume for the purpose of this hypothetical that the Los Angeles Police Department had run PCR testing from beginning to end on items 47, 48, 49, 50, and 52 before
Same objection.
Sustained.
before they were ever sent to you.
I'm sorry, Your
Sustained.
Honor.
Dumbass.
May I have a sidebar, Your Honor?
No.
Proceed.
Dr. Codd, if a laboratory had done PCR typing on the samples that they were submitting to you, wouldn't you want that laboratory to provide you with as much information as possible about the quality and quantity of those samples?
Same objection, Your Honor.
Oh,
It really probably wouldn't make any difference because we would be doing that assessment as we went along.
Well, would you agree that you do not want to process or do extractions at the same time of samples that have very, very little DNA with samples that may have relatively large amounts of DNA? Would you agree with that?
I'm sorry, objection vague.
oh,
If there was a way to know that, then, and depending on the differences in amounts,
Right.
you might try to not do the extractions at the same time. But for the most part, there isn't a way to know that. And never, I'll stop there.
But one of the ways that you knew it is you can do a yield gel. The strong recommendation of the manufacturer of the kit that you're relying on.
Objection, assumes facts, not in evidence.
Well,
oral. Oral.
It might be the strong recommendation of the manufacturer of the kit. However, the manufacturer of the kit is not a group that's engaged in routine forensic DNA typing. So,
was this kit,
I'm sorry, could the witness finish her
I thought she had, I apologize.
so a laboratory with some experience might, like any recommendation, might decide to accept that recommendation or not accept it.
Isn't there a statement actually on the kit by the manufacturer that this kit is designed for forensic application?
That's right, but the manufacturer of the kit is not a forensic DNA lab.
To your knowledge,
I'm sorry, could the witness finish her answer, please?
I'm done.
All right.
Proceed.
isn't the kit explicitly and expressly warranted to work only if you follow the directions on the kit? Isn't that a warranty given by the manufacturer?
Yes, but that's in terms of the salt solution concentrations and the temperature and the quantitation, that is the amount of DNA you add. There's no specific directions they can give you to ensure that the rest of your handling is good or bad. They can only tell you if you have the thing at 60 degrees, it'll work, and if you don't, it won't.
So is it just, so I'm clear on this, is it your position that the express instruction from the manufacturer that you are, quote, to perform DNA extractions from samples containing high levels of DNA separately from samples containing a low level of DNA is something that the people who utilize this kit are free to ignore?
Yeah.
I'll withdraw the objection.
Yes, and I mean, what's high and what's low? I mean, this is going to be the judgment of the people in the laboratory. That's not a specific instruction. It's a vague instruction.
Granted, Dr. Cotton, what's high and what's low is something that has to be determined by the in particular laboratory, but once that assessment is made as to what is high and what is low, wouldn't you agree that it is critically important to follow the instruction that that which you consider a high level of DNA should not be extracted at the same time with that which you consider a low level of DNA?
Objection asked and answered, and I think counsel's arguing with the witness.
Overruled. We have asked this question. Again, I'll allow the question and answer one last time.
I have stated, I think, earlier that depending on how great a difference in amount of DNA you have, if it's a very great difference, then one would prefer, if you were able to know ahead of time, to deal with the large amount of DNA or evidence that had a large amount of material on it separately from the smaller amount. And that's a relative decision for any specific laboratory.
Is the manufacturer of the kit the same entity that designed the validation studies for that kit?
Well, they certainly did a lot of validation studies, but they are not the only group that did validation studies using that kit.
Now, you mentioned in terms of your testing of items in this case that one of the items you were asked to do DNA profiling was the steering wheel inside the Bronco. Is that right?
From one item of evidence from this, I don't know if there's more than one item of evidence from the steering wheel, so we had a item of evidence from the steering wheel.
Okay. And that one item of evidence was a blood swatch taken from a smear on the steering wheel. Is that correct?
That's right.
Let me get the board. Now, would you agree, Dr. Cotton, that interpreting mixed stains is a more demanding challenge to the forensic laboratory than interpreting a stain that only has a single source?
Sure.
And when you see more than two versions of a particular gene, that enables you to determine that there's more than one contributor to that stain, correct?
Yes.
However, if you see 3 or 4 versions of the gene, you can't necessarily tell whether there's been 2 contributors or 3 contributors or more contributors. Isn't that correct?
That's exactly right.
And that's one of the difficulties in interpreting mixed stains.
Yes.
And with respect to the stain removed from the steering wheel of Mr. Simpson's Bronco, your DQ alpha typing method showed the presence of 3 different alleles. Is that correct?
That's right.
And I think you said yesterday, the day before that, and the day before that, that one should only inherit 2 versions of a gene. Isn't that correct?
Yes, except under very rare circumstances, so
All right.
we'll just assume 2.
And certainly, Dr. Cotton, each of the individuals who you typed in this case as reference samples, namely Mr. Simpson, Nicole Brown Simpson, and Ronald Goldman, each had only 2 alleles for the DQ alpha marker.
Yes.
And when you typed the DQ alpha markers, when you typed that stain on the steering wheel, you found that there were 3 separate DNA types, correct?
Yes, we did.
You found the 1.1 version of the gene present, right?
Yes.
You found the 1.2 version of the gene present, correct?
Yes.
And you found the number 4 version of that same gene present.
Yes.
And initially on this board that you saw, the prosecution had written that the only one of the 3 people not excluded was Mr. Simpson, correct?
Yes?
But I take it you did not help the prosecution prepare this exhibit board, did you?
I saw some of the boards to make sure that they were right, and I don't know if I don't remember if I saw this one. I might have.
But the reason
But there
that-
was a mistake on it.
Okay. And the reason, looking up at the top, you said that Mr. Simpson is of a... Can everyone see the top? Okay. But looking up at the top, that Mr. Simpson is a type 1.1, 1.2.
Yes, he is.
And you can see a 1.1, 1.2 in this mixture.
Yes.
And that's why he's included.
Well, and the polymarker data
Fine.
as well.
Well, actually, on the polymarker data, if you look at it, isn't every different version of every polymarker included in this mixture?
I don't remember without going back and looking.
Please take a look.
What's the... We're at 29.
29.
Okay. Yes, you're correct. There are all the possible alleles for the polymarker are present in that sample.
So in fact, if you just looked at the polymarkers and nothing else in this case, you would have to say that there'd be almost no useful information in the polymarker results because the entire human population could have contributed to that mixture.
Assuming all the intensities of the dots were, assuming the dot intensities weren't informative, and I don't recall that they are.
So the key information here in this particular case for you was not the polymarker results, but rather the DQ alpha results.
For this sample.
Yes. And not only were you able to not exclude Mr. Simpson, but you were not able to exclude Nicole Brown Simpson, isn't that right?
That's right.
And that's because Nicole Brown Simpson is a DQ alpha type 1.1, comma 1.1, right?
That's right.
Meaning that she inherited the same version of the gene from her mother and her father.
Exactly.
And so because you see the 1.1 allele present in this mixture, that 1.1 allele could simply be 2 copies of the DQ alpha typing from Nicole Brown Simpson.
Yes.
However, you in fact excluded Ronald Goldman as a contributor to this mixture, isn't that correct?
Yes, we did.
And the reason you excluded Mr. Goldman as a contributor to this mixture is that Ronald Goldman is of a type 1.3, comma 4, correct?
That's right.
And what that means is that Ronald Goldman, his DQ alpha type, has 2 alleles in it which are different from one another, correct?
That's right.
One of his alleles is the 4 allele, right?
Yes.
And one of his alleles is the 1.3 allele, correct?
Yes.
And so if this sample contained a portion of Ronald Goldman's blood or biological material, you would also expect to see the 1.3 allele and not just the 4 allele.
Yes.
And it was on the basis of that that you excluded Ronald Goldman as being one of the contributors to this mixture.
That's exactly right.
Jen, thank you so much for the 25 PayPal. I really appreciate it. Thank you. You keep the lights on.
So would you agree, Dr. Cotton, that based on your analysis, that the number 4 allele that you see present in this mixture from the steering wheel must come from someone other than Mr. O.J. Simpson, Nicole Simpson Brown, and Ronald Goldman? Isn't that correct?
I would.
Now, this other person, just let me get out my diagram. Do you have the other small?
Perhaps we got to move that over here because that one, height-wise, is hard to see unless it's in the middle. Flip. So stipulated. All right, Mr. Neufeld, can you work with this?
Give it at my artwork, I'm sure it'll be adequate.
All right, Mr. Scheck, Mr. Scheck, don't go away. You may need to steady that.
All right. Good. You can do better than this. Can't you? Only in California. All right. Dr. Cotton, now this third person, who cannot be Mr. Goldman, who cannot be Nicole Brown Simpson, and who could not be Ronald Goldman, who has, we'll call him, all right, we'll call him actually the fourth person, because he's one of the three people whose reference samples you tested, all right? And this,
Objection vague.
this fourth person has the 4 allele, correct? As
Yeah.
one of his 2 or one of her 2 alleles, correct?
Well, yes, if we assume a person in there
Right.
has a 4 allele.
Okay, let's start with the most simple assumption first. All right?
Okay.
Now, this person who has the 4 allele also has 2 alleles inherited, one from his mother and one from his father, or one from her mother and one from her father, correct?
Yes.
And so this person could have different possible genotypes as well, correct?
Of course.
This person could be, given the presence of the 1.1 and 1.2, could have as a genotype a 1.1, comma 4, correct?
Yes.
This person could have as a... I'll move in a second, I'm sorry. This person could have as a genotype a 1.2, comma 4. Whoops. A 1.2, comma 4, correct?
Yes.
And this person could also have inherited the same version of the gene from both parents and be a 4, comma 4, correct?
Yes.
Okay. And those are 3 possible explanations for a genotype for a fourth person. If the fourth person contributed the number 4 allele, correct? Those are
Those
possible
are the 3
genotypes.
possible. Those are the 3 possible genotypes for a person in that mixture. If that person's first allele is a 4.
Okay. Now, you take that down. Oh, what would be next in order, Your Honor?
That would be 1150.
Now, Dr. Cotton, I'm going to ask you a hypothetical. I'm going to ask you whether or not that hypothetical is consistent or inconsistent with the observed evidence in your laboratory. Assume that Mr. Simpson cut himself in his home and walked out to the Bronco to get something from his car and bled in his own Bronco.
Objection, I'm
Assu-
sorry.
Sustain.
Assume, Dr. Cotton, that some of Mr. Simpson's blood is in his own car.
Same objection, Your Honor.
So,
Overruled.
and assume, Dr. Cotton, that some other person, other than Mr. Goldman, other than Nicole Brown Simpson, other than O.J. Simpson, had come into contact with the blood of Nicole Brown Simpson, and then entered that Bronco and made a smear on the steering wheel, having touched Mr. Simpson's blood.
Same objection, Your Honor.
Sustain.
Dr. Cotton, if somebody else who is either a DNA type 4, comma 1.1, or 4, comma 1.2, or 4, comma 4, touched Mr. Simpson's blood and touched Nicole Brown Simpson's blood and touched that steering wheel, would that be consistent with the stain you
Improper
found on the
hypothetical, Your
wheel?
Honor.
Sustain. Juries to disregard the implication of the question. All right, ladies and gentlemen, we're going to take our recess for the morning session. Please remember all of my admonitions to you. Do not discuss the case amongst yourselves. Don't form any opinions about the case. Do not conduct any deliberations till the matter has been submitted to you. Do not allow anybody to communicate with you with regard to the case. Have a pleasant weekend. Enjoy the activities. See you Monday. All right, we'll stand in recess till 1:45. had been raised a discovery, I guess, Griffin issue regarding continued
Sanctions.
testing at DOJ. And Mr. Scheck, since you raised the issue, do you want to advise the court the nature of your concerns?
I think my concerns can be simply stated. I think it's close to 2 months ago, or it's hard for me to remember, before the examinations of the criminalists began, Mr. Harmon requested to combine all the samples in the Bronco, 303, 304, 305, of which 303 and 304 being stains that were in the location originally of 30 and 31. And they took all of it, 30, 31, 303, 304, 305, after notice to the court, and asked for permission to combine them all together to do RFLP testing. I think that we all believed that they were going to commence with that soon after giving us notice.
Immediately, if not sooner.
Immediately, if not sooner. And the concern that I expressed at that time, and plainly the reason for the testing, is that there's ambiguity with respect to the test results on these combined stains in the Bronco. I think Mr. Harmon indicated, and the prosecution indicated, that they wanted to combine all these stains to do RFLP testing to get more information and greater clarity with respect to the results, one way or the other, to exclude or include various individuals in terms of having greater information.
All right, well, let's assume, Mr. Scheck, what you say is true. What do you want me to do about it and why?
Well, I think that the problem is that since they have not even begun testing, and we know that the combined samples is something on the order of 72 nanograms of DNA total, I think, at best, that this particular form of RFLP testing is going to take between 4 and 7 weeks, because what's going to have to occur if they're going to get results is laying the order reds for long exposures. So this is, in my judgment, a tactical decision by the prosecution to gain an advantage in terms of possible cross-examination of the witnesses and then rebuttal case. It's just more of what I think has been going on all the way through, which we've complained about to the court from the beginning, but this I think is extreme. This is now at the point where it's very clear that this was done not in good faith, but for purposes of obtaining a forensic ambush in this trial, if that were to occur. It also precludes the defense from having any access to the samples during these periods of time if they were not going to engage in this testing. So I think it presents a discovery problem. The cases that we discussed long ago...
Well, Mr. Scheck, let me
yeah.
redirect your thought process. Let's assume that everything you've said so far is true.
Right.
What do you want me to do about it, and what's the legal basis for doing that?
The problem is the only relief at this point is preclusion. I don't know of any other real remedy for this at this point in time, by the way they set it up.
So you want me to on the basis of this, you want me to make a finding of bad faith, and based upon that, preclusion of any results?
Yes.
All right. Mr. Harmon, good afternoon.
I'm trying to freaking relax. Trying to calm myself down.
Good afternoon, Judge. Now that the jury has seen the kind of evidence we have, the ambush already happened, and the overwhelming mountain of DNA evidence has begun to cascade right where it belongs on Mr. Simpson. While it may have been intriguing and entertaining back in October or whenever these discussions happened before I started coming down here, that our tactics, our tactical decisions, precluded them access to the DNA evidence in this case. You are aware, and they are aware, that they have never gotten one of the many, many remaining swatches in this case to test for DNA typing. If they have, it's news to me, which is always possible, but I'm not aware of it. So we can cross that one off the list as a good faith argument. Nobody's precluded them access. There's a bunch of stuff over at LAPD SID that we would love to have them test for DNA typing. So let's strike that from our agenda. Practically speaking, although no objection has been made, Mr. Sims is going to have to come back after this chunk of his testimony, because there are tests, specifically on 117, that have been going on for quite some time, that haven't been reported. And while Mr. Scheck hasn't objected to me presenting, if he doesn't mind me objecting to having Mr. Sims present them when he testifies, hopefully next week, even though he hasn't gotten the reports, but he knows what the results are. I'll be happy to do that. I'd like to finish him in one session. But I know it's not fair because we don't have a report. And so Mr. Sims
One session or one sitting?
I misspoke there. One lifetime, maybe.
God, you got my hopes up.
Mr. Scheck, as part of this bad faith, said, I wrote this down, they have not even begun testing. And I'm as shocked to hear that as I'm sure Mr. Sims is. They've begun testing. They just haven't begun the part of the testing that he's dying to know if the other shoe is going to drop out of. So the testing has begun. Mr. Sims has a life. The DOJ lab has a life independent of this case. You know, aside from those are my normal comments that have nothing to do with the legal issues. There is no legal issue that allows them to do what they've asked you to do here. They have consistently whipsawed the defendant's right to a speedy trial and said, but this isn't fair, we're never going to know. And if they'd waited, they would have known all this ahead of time and maybe rethought their tactics in this case as the DNA test unfolded. But the fact of the matter is, they chose when to go to trial. And we have done fairly well. No case has ever had the amount of DNA evidence analyzed as has this case. So I think the court realizes that at this point, the arguments that we have precluded them access, or this will continue to preclude them access to evidence, when, except for the intriguing 47, 50, and 78 that weren't done for DNA testing, they've never done any DNA testing on any of the evidence. That's not a sincere argument. But there's simply no legal basis for it. I wish we were done. Mr. Sims wishes he was done. Unfortunately, once you step out of this courtroom and out of this building, there's a whole world and a life out there, and everybody has to balance, except for us, everybody has to balance that, and we're just stuck in this for the time being. So there's no legal basis. If they'd hurry up with their cross-examination of witnesses, maybe we wouldn't get around to testing it, and there wouldn't be any ambush. But, you know, the lengthy cross-examination that we saw in April just makes it easier to finally get around to the last set of tests, and that's about the last set of tests. So if they were concerned about it, maybe they should have cut off some of their cross-examination and precluded us from practically being able to get to these results. Thank
Mr.
you.
Harmon, when did the actual combined RFLP testing begin?
Mr. What's your name? Clark has a recollection that it was April 3rd. Mr. Sims is... Could I ask him? He's got his notes here. I just didn't bring them here. Because we had those discussions, and I can tell you that things have been done towards the typing.
All right,
but
the record should reflect that present in the audience is Gary Sims, Department of Justice. Good afternoon, Mr. Sims.
Good afternoon.
Do you have your notes regarding the commencement of that RFLP testing?
Yes, I do.
All right. Can you tell me the date? All right.
I think also, can I just speak to...
I would welcome him to define it. I'm only going on based on what Mr. Harmon told me and
Certainly.
everything else, and the original source is Mr. Sims, and I welcome any remarks. I'm sure that they're completely accurate.
I remember at first there was a legal hurdle we had to overcome, and there was a declaration in which I said that I would save swatches, which I did. And I don't remember the exact date of that declaration. And then that was litigated, and then the samples came back up to us, it looks like on March 9th. March 9th was when we started, we got some of those samples back that we wanted to do additional testing on. And the actual completion of the test that we did through the extraction, we did some DQ alpha typing, et cetera on those, and that, including quantitation and some other things, and that was completed about early April. So since sometime in early April, I did.
Can you pin it down a little closer than early April? And Mrs. Robertson, could you find the motion with regards to the prosecution's motion to for permission to combine those items for testing? And the declaration by Mr. Sims should give me some idea as to where we are.
I don't think we
Hold
filed
on.
a formal motion.
Your Honor,
There was a declaration.
the note I had would be April 4th. My
April.
notes say, this is on page 239 of my lab notes, April 4th, 95, DNA 30, 52, 53, that's those three combined samples, proceed to RFLP. So, April 4th.
April 4. And Mr. Sims, when do you anticipate having final results and completing the report as to that test?
For that particular sample, it may be that we can only get a few probes off. So we may have to go with just some partial information as far as the probes that we can see.
right, when do you anticipate knowing the results?
The process itself takes several days as far as restriction, gel, blotting, and then we'll also, of course, have to have the probing done. So I would think we've probably got maybe a month and a half of work, something like that.
Still to go?
Yes, maybe 2.
Are we going to be done by then? That was my hope.
Well, we may have preclusion by passage of time. All right, Mr. Sims, do you happen to have in your case notes there a copy of your declaration?
I don't think I do, Your Honor.
All right, then I'll have the clerk find that. I just want to get the declaration so I can place our legal discussions in context time-wise. All right, Mr. Scheck, any other comment?
Yes, just one. I just note for the record that I don't want to violate any of the court's rules with respect to making comments. I'm trying very hard, and Mr. Harmon has a very colorful way of expressing himself, and I'm not amused. And I will not take the bait of answering all these things, but I want the court to know I'm not amused. There's one thing that does require note. Once again, Mr. Harmon is making statements about what he knows the defense did or did not do in secret testing. That motion is still before the court. That record is still before the court. I don't think those are proper comments. I don't know how he knows any of this, and I'm very concerned about it. And I would call the court's attention, and I will file a letter memo on Monday, to the case of County of Los Angeles versus Superior Court.
Do you want to know how he knows that you have not gotten any of the samples that are still in the laboratory? Because they're still in the laboratory. If you had taken them out of the laboratory, he could safely assume that maybe you're doing testing. But since you've never actually gone to the lab and taken the samples, he can be 100% certain, with 100% accuracy, that you, sir, have not done any testing on them, dumbass.
At 222 Cal App 3rd, 647.
He irritates
Since it's my
me.
opinion, if the court consults that authority, that Mr. Harmon's previous admissions in our discussions of his efforts to find out about privileged communications and testing, if any is done by the defense, already by his own admissions, is unethical, violates rules, and actually merits the sanction of recusal from the case. I haven't said we're going to ask for that with respect to Mr. Harmon, but it's serious, and I don't think he seems to understand that. And he did it again today.
All right, thank you, counsel. What I will need to do is review the record with Mrs. Robertson to determine the actual dates of the declaration filed by Mr. Sims, and then rule after I have that information available to me. Mr. Clark, you mentioned something earlier this morning that we needed to resolve. Clark, that's you.
Actually, I wasn't looking to remember who I was.
All right.
I'm trying to recall what we had left. I thought.
All right, anything we need to do on Mr. Blazer? You're raising the issue regarding Dr. Weir's...
Make sample calculations and Mr. Thompson is prepared to present our position on that.
All right.
If they're ready to talk about this.
I thought we were going to go through this phase with Dr. Cotton, and then she was going to have to return anyway because of the court sustaining the objections to foundation on, for instance, frequency calculations, including the Department of Justice, as well as there are some other issues that relate to results from the Department of Justice that I was going to ask Dr. Cotton about. So I may have been under the wrong...
All right, so you were not anticipating presenting this until Robin Cotton round 2?
Exactly, because there is a number of pieces of information that need to be looked at as far as to calculate these frequencies. This was done in very much a rush. And frankly, I don't think it's been too fast to be able to present this information properly and calculate it properly. So Dr. Cotton is still working with Dr. Weir to be able to calculate those frequencies. I'm not trying to give the court the impression we don't plan on doing that. We do. But it's not as simple as taking a few days to calculate as it's turned out.
Right.
Well, Your Honor, two things. One is...
Well, wait, who's going to address the issue? Mr. Thompson, Mr. Blazer, or Mr. Neufeld?
No. Professor Thompson was going to address the actual numbers that were presented by the prosecution in a memo written by Dr. Bruce Weir. All I wanted to do is remind the court on a preliminary level, procedurally, that it was your ruling, not that they were going to wait and present numbers at some other occasion on some other date, if and when Dr. Cotton returns to court. It was the court's ruling that they were compelled to produce some number which aggregates the respective frequencies in the population of all those people who are not excluded. And the issue is not whether they use a product rule or a ceiling principle. They can use whichever one of those numbers that they deem appropriate given the outcome of the Fry issue here, but that they had to produce a number. And that it was decided by agreement, I believe, at a sidebar, that the way it would be done, since we couldn't conclude that issue on what the number was before I commenced cross-examination, that he would be permitted, while Dr. Cotton was here these couple of days, to reopen his direct examination just for that limited purpose. And so he would either do it as a reopen or he would do it during the course of redirect. And what I said is, and he agreed at that point, is I was not going to comment on his failure of presenting those numbers during the direct.
Well, here's the other problem, though. We know the scheduling problems that we have with Dr. Cotton. We know now Mr. Clark is indicating to me that he's not ready to present these numbers. I can't force him at this point. If he wishes to recall a witness during the course of his case in chief, he's entitled to do that.
1 second. What I would ask to be able to do at this point, Your Honor, if that's the court's feeling about this, I mean, frankly, in terms of scheduling, I don't think it's a big problem. As I informed the court earlier today, I will finish my cross-examination on Monday, and now I've actually said it on the record in open court as well, so it's no longer a confidential matter, but I do make that representation. And she has to finish by Wednesday, I believe, with her schedule. So certainly that's more than enough time for redirect, as well as to handle any anticipated problem with these numbers. And I think
Well, let's see where we are. Mr. Clark, when are you going to have your final numbers calculation? When do you think?
I don't know the answer to that. It's a much more complex task than it might seem on its face, and the two of them are working together quite a bit. I mean, intensively in the time that's been available over the last few days. I can ask Dr. Cotton how long she anticipates that would take, but I don't want to be in the position of having to produce all of a sudden a frequency that's the product of rushing, and then all of a sudden it's attacked because it was forced, it was compelled to be done, and it wasn't examined sufficiently. So, whether under a misapprehension or not, I think the additional time will help ensure the accuracy of those numbers, but I'll be glad to ask Dr. Cotton how long she anticipates this meeting.
All right. How long will it take you to contact Dr. Cotton? Can you do it right now?
I believe so.
I just want to remind the court, Your Honor, one of the
Why don't you
things.
just
It was
ask
a week
Neufeld
ago
what the answers
that you
are?
had asked Mr. Clark to have those numbers ready just in case that was your ruling. So they've had a week to prepare those numbers in anticipation of the court's ruling. So it's not something that was a rush to judgment, if you will. It's something where they had plenty of time to...
Excuse me, sir. Dumbass. Are you saying that Dr. Cotton, who has been sitting in that chair every day, all day long, was supposed to be finding the frequencies of a question that may or may not be asked? Was she supposed to do that at night on her time off? Is that what you're saying?
to process it. And, in all due respect to what's involved here, I don't believe, for instance, with item 29, for instance, it takes days or weeks or even hours to answer the question that's posed in the National Academy of Science NRC report, which is simply aggregating the frequencies of that portion of the community that can't be excluded.
All right. Let's take 5 minutes, and Mr. Clark, why don't you give Dr. Cotton a call, and let's see when we might anticipate, because I'd like to wrap that aspect of it up this round if we can. Okay.
Your Honor,
Right.
but may I be heard?
On what?
On something unrelated to this.
All right.
Maybe just to set as time for
Yeah,
scheduling, 'cause I noticed Mr. Cochran's not here and Mr. Douglas is not here. This morning, the prosecution was provided with some additional discovery and a supplemental defense witness list, which includes about a dozen new names. For a few of these people, the discovery which was provided is just in the nature of rough notes, which are incomprehensible. There are no dates of allegations. That apparently they contain allegations. We can glean that much. But this is incomplete discovery, and it's brought up to the fore a problem we've been wanting to address for a while in terms of incomplete defense discovery. And that is that on the combined defense witness list, there's over 50 people still on their witness list, excluding American Airlines passengers on the flight to Chicago, which is quite a few people by itself. Excluding that, there's still over 50 people on their witness list for whom they have not provided discovery, and we never initially provided discovery to them. So while there are a number of witnesses that we can kind of glean the nature of what they'd be testifying to based on discovery we provided to them earlier at important times, such as some of the police officers, there are quite a few witnesses that we've never heard of and we know nothing about. And it's becoming difficult to believe that there has not been defense investigation culminating in some kind of statements from these witnesses. So I have a list of those. I was hoping Mr. Douglas would be present this afternoon so that I could ask him about it. Perhaps I could lodge that list with the court and fax a copy to the defense, because it's certainly getting to the point where we're getting very close to the defense case, and we don't have discovery on a lot of their supposed witnesses. Maybe they're people who they are going to be taking off their witness list, but if that's the case, they should be doing that.
All right,
It's
once you
your
lodge your list with the clerk,
birthday? Is it your
send
birthday?
a letter to Mr.
Happy birthday, Jude! Happy birthday! It's your birthday today! Oh my god, I hope you have a great day. I hope you get something very, very nice, even if you have to get it for yourself. Get something you think you shouldn't have. Like, I'm not going to buy that for myself. I'm not wasting that money. Just go waste it. Go get you something pretty. I don't know, like a bedazzled Windex bottle. Did you guys ever see those? Oops. Hold on, I'm going to show you what I mean. This is what you should get yourself for your birthday. For absolutely no reason. No good reason anyway. Oh, I can't. I don't know. Let's see if I can. I want to try to show you this site. They're only $105. All right, let's see if I can show you this site. Add a window. There we go. I can show you. This is what you need for your birthday. This is it. This is what you need. And you know why there's so many for sale on Etsy? Because people buy them. They actually work. They actually do have Windex in them. And they work. And they sell for $100. A Windex bottle. Look. You need a little spinny tray in your living room so that when people come in, they can see and with lights on it, so they can see the Windex bottle spinning around. For a mirror, a bedazzled mirror under it works well too, but I like it spinning better. Oh my god, that's like 3 eggs worth of bottles right there. You can get the whole set. Hold on. Tito's vodka. Tito's vodka and Windex. That's... Oh my god. There we go. Back to work, guys. Why is it black? It's not black on my screen. Oh, that's the wrong. I lost OJ.
People are never going to forget.
I lost it. Is this? That is just not it. There. I'm an idiot.
Fax a letter to Mr. Douglas this afternoon, advise him of your concerns, and if it's necessary, we'll set it for a hearing.
All right, thank you, Your Honor.
All right. Okay, let's take a 5-minute recess. Mr. Clark, why don't you chat with Dr. Cotton?
Your Honor, what?
I am definitely a fabulosa kind of guy. I use a lot of bleach though, so it's fine.
R markers. Dr. Cotton testified that that method, in fact, can be used of summing up these various genotype frequencies. As to the RFLP results, that is the mixture on the boot stain, item number 78, they don't believe, that is, Dr. Cotton doesn't believe it's appropriate to assign a frequency. It can be done, but I hope the court isn't under the impression that when she testifies about numbers as to that particular item, that in fact she's going to represent that as this is an appropriate way to do it in the face of what I anticipate is going to be a defense attack on those numbers. So it's a difficult situation at best. And perhaps the defense can tell us what number they would like to see attached, for instance, to that mixture on item number 78, and perhaps we can agree to it.
Your Honor, the problem is, which is what
That's
the
what I
NRC
said.
report says, and which the court accepted, is that you can't present the DNA evidence of a match or even a consistency without a probability. If the people feel that they cannot produce a number for those items, then they have no business producing the suggestion that there's a match in the first place. That's what the scientific community says. That's what the law is in the state of California, and that's what should have happened here. And to that extent, Your Honor, I believe that, this it isn't fair on a very fundamental level. If they have a number that they intend to introduce for each of these items, we'd like to hear the number, obviously, outside the presence of the jury first, so we can at least question it, because frankly, if it's a number just pulled out of thin air, obviously it would be inadmissible, and there may be other grounds for precluding that number and compelling them to go back to the drawing board to produce another number. But I am somewhat concerned, that being the law, and you making a decision beforehand, that before they could actually testify to a match or a consistency, or however you want to describe it, for item number 78, that they didn't have.
Did that lawyer just sit there in open court in front of the entire nation and say, we want to see the answer to this question before it's presented to the jury, because if we don't like it, we're going to make them go back and get a different number? Is that what he just said in front of the entire nation? If they put a number that we don't like, then we're going to make them go and get a different number? These are scientists. They don't just make up numbers and then get a completely different number if you don't like it. That's okay. In the 90s, that's not the way scientists acted. Now, I guess politically they have to, but in the 90s, when a scientist came up with a number, it was generally believed among Americans that was correct, because the scientists, were smart and they knew how to get numbers. Now, facts are opinions, but that's different. This is in the 90s.
Have a number that they could put forward with that other expert opinion, and that raises some very, very serious questions. That's all I'm saying at this point. So we'll have to address it Monday morning, but there may be a need to strike that portion of the testimony or give other curative instructions.
Let's see the number. Let's wait till you see the numbers, see what you think, and if we can go forward, we will. And if we need to have a hearing out of the presence of the jury, we will.
Right. One other matter, Your Honor.
Don't forget, we don't get to that point until Mr. Clark has the opportunity to reopen, to represent. All right?
Oh, sure.
Okay.
I agree.
Right.
One other matter, Your Honor.
So it looks to me like 4:30 Monday, we may get to this.
Hopefully earlier. It may surprise you. One other item. Carl Douglas brought to the court's attention earlier today a matter involving a representation that had been made on the record yesterday, suggesting that Mr. Simpson, when he was arrested, had thousands of dollars either on his person or in his bag. And Mr. Douglas brought that to the attention of the court because we had never received any discovery and we had no information to support that wild accusation. I think we have now learned, or we will hear from the district attorney, hopefully, that in fact that accusation that was made yesterday had no basis in fact to support it, was not correct. And what concerns the defense, Your Honor, is again, and it has happened before, of an instance where certain statements are made on the record, not in front of the jury, obviously, because they're not hearing this, but to another jury. And we just would like the court to be very careful that if this kind of thing happens in the future, that some type of corrective measure should be taken by the court. That's all.
Ms. Lewis, do you want to address this for the people?
Yes, Your Honor. During the course of the argument in favor of our calling Mr. Kardashian to the stand, I said that I believed that within the black bag was several $1,000s along with a gun and the disguise. Apparently, and I was in error in believing that the money was inside the black bag. It was on Mr. Cowling's person, some $8,000 to $10,000, and I'm informed it was returned to Mr. Cowling's. So it was within the Bronco, but not within the black bag. And I don't mean to have misled the court in any manner. That was an offhand remark that wasn't germane to the motion we were discussing.
All right. Mr. Clark, when do you anticipate that Dr. Cotton will have this calculation available? You said Monday, but is there a possibility that could be faxed to counsel earlier so that they can have some opportunity to evaluate it, so maybe we can cut to the chase on Monday?
Yes, I'll obtain Mr. Neufeld's fax number and we'll fax it as soon as we can.
Terrific. Okay, appreciate that. And let's see, then the only thing remains is for the court to evaluate Mr. Sims' declaration and see if there's any problem there. But I see this as a premature objection at this point. All right.
Mr. Sims pointed out one thing with respect to that. I'm appreciating the declaration, and Mr. Scheck, I'm sure, will clarify how he misspoke on the point. all of those samples were not consumed at that time. And
I don't think, how could he have consumed them? He hasn't done the tests.
well, you'll see what, he said they were all consumed, that's my recollection, and
Whatever, I'm only going on what they tell me, and I brought it to the court's attention because I was concerned that the testing hadn't begun.
All right, I'll note the objection. I'll evaluate the declaration. At this point, though, I think the objection's premature. All right.
We'll try to get it this afternoon, I'll get it to the court this afternoon, they're trying to get it now.
Fine. Okay, then I can spend the rest of the afternoon working on the other rulings I need to make.
Thank you, Your Honor.
Can't
All
wait,
right.
you can't wait.
Not like I haven't been busy. All right, we'll stand in recess, 9 o'clock. Thank you, counsel.
I gotta go 19 more minutes, CJ. I got to, or we're never gonna get this trial over. I have to
Connection
hit
with
2
mixtures
hours
such as
every
the
day.
mixed stains in the Bronco and stain 78. Last week, the court ruled that statistics must be presented in connection with those mixtures so that the jury would know what to make of them. What to make of the fact, for example, that Nicole Brown Simpson is included in the Bronco mixture.
I understand why I did it.
Over the weekend,
point?
we received reports from the prosecution regarding the statistics that they intend to present, and we have serious problems with them. We think that the reports that they've shown us with what they plan to do fail to comply with the court's ruling on this matter, and we have a series of objections to them that we want to state now.
Right.
I think at the time of the court's ruling last week, I think we all contemplated that the statistics in question would be frequency statistics to be computed in accordance with the National Research Council's guidelines. So, for example, to allow the jury to evaluate what it means that Nicole Brown Simpson has genotypes consistent with certain stains in the Bronco, the jury needs to know what percentage of people in the population at large have genotypes consistent with those stains and what percentage would be excluded. And the National Research Council provides a very simple, straightforward way of doing those calculations by summing the matching and non-matching genotypes. What we got from the prosecution and what they intend to present apparently is not frequencies, but something called likelihood ratios. Likelihood ratios are a ratio of two conditional probabilities, where a conditional probability, as you probably know, is a probability of one event calculated on the assumption that certain other events occurred. These likelihood ratios, we know of no precedent for the admission of likelihood ratios in a criminal matter. In the notice of objections we filed with the court in March, we stated a series of objections to likelihood ratios. All of the objections we stated in our previous memo apply to the likelihood ratios they're offering here, and more. We think the particular likelihood ratios that they are offering that are found in a report prepared by Professor Weir of North Carolina State University are lacking in foundation because the assumptions that are predicate to the conditional probabilities don't necessarily jive with the facts of this case, and in some cases are clearly inconsistent with the prosecution's theory of the case. So what they've come up with is not something that complies with the court's order. It's a convoluted attempt to do an end run around the court's order and present a complex form of statistical analysis that is unprecedented and that we think is quite misleading. Should they be allowed to present this or attempt to present it, we think a 402 hearing may be necessary to evaluate whether these likelihood ratio statistics are in fact admissible. We think this is a failure to comply with the court's order. We ask that they be ordered to present the appropriate statistics computed in accordance with the National Research Council's method, or that the DNA mixture evidence be struck from the record.
All right, Mr. Clark.
Yes, Your Honor. Again, this raises the question that I broached with the court Friday. What numbers does the defendant want? I mean, perhaps we can agree on that. But more importantly, what the defense received was materials from Dr. Bruce Weir that this witness, I believe the testimony will show, understands the calculation process, can perform it herself, and will do so. Contrary to the defense's assertion, there's no intent on our part to introduce likelihood ratios. There's a good deal of data in this report that we're referring to that's approximately 12 pages in length, and it includes frequency information as well that I plan to elicit from Dr. Cotton during testimony.
Do you plan to elicit an aggregation?
Could I have just a moment? Possible for Dr. Cotton to answer the court's question instead of it being through myself as a conduit?
Certainly. We'll save some time, I suspect.
Would you like her on the witness stand?
No, Dr. Cotton. Good morning. What is it that we are going to be hearing, and how will it be presented?
Let's take the RFLP separately from the PCR for a moment, although the calculations are done the same. For the RFLP, we intended to just discuss the two genetic locations where on the individual films you have evidence of a mixture that would be MS1 and G3. and to simply give the figures for what is the probability you would pick a pair of people from the population that would have this combination of genotypes that would give you this result. The same, so for the RFLP, it's simply giving that figure for the MS1 locus and giving that figure for the G3 locus. For the PCR, the figures are done likewise. That is, what is the probability you would pick a pair of individuals from the population? So it takes into account all possible pairs that could have given this this set of alleles, and sums those, and then says, what's the probability I would pick two pairs of people that could give this? In his report, Dr. Weir does provide information about likelihood ratios, but it was not our intention to discuss that.
All right, what are the numbers that we're going to get on the RFLP and the PCR aggregation?
I'll have to get those out of my briefcase. It's in my briefcase.
How about a ballpark figure?
The ballpark figures for the RFLP range sort of like 1 in 80 to 1 in it's either in the hundreds or thousands. It is not in tens of thousands. The PCR numbers are similar. The reason that they're similar is that for the RFLP, you're just looking at a single locus and giving information about that locus. The PCR you're giving the composite information across all of the loci that we have done for PCR.
All right.
To give the court an example of sometimes the complexity of this, if one were to take the boot drop, item number 78, and determine what's the probability of finding the 14 bands that were located, it's, for instance, approximately 2 with about 12 zeros behind it. I mean, they're astronomical, so it all depends on how the question is framed. It's not our intent to present that type, at least during the direct examination. But I think the court's getting, and I'm sure the court's getting a feel for characterizing this question can be difficult, but I think at least it's our intent to approach it in a very conservative fashion.
All right, Mr. Neufeld, any comment? Excuse me, Mr. Thompson.
Your Honor, I think it's clear from what's been said that what they're offering is not what the National Research Council called for.
All right, National Council, you have the same information before you. What numbers do you come up with? What
Well, let me show you. I prepared a chart, Your Honor, showing what we think is the correct computation with regard to stain number 29, the Bronco steering wheel. And with your permission, I could show you in council a copy.
Please.
Okay. Now, Your Honor, the frequencies in this chart are taken directly from Cellmark's own frequency data that was disclosed to us in Discovery from DNA Discovery page 1520. And in order to compute the probability or the percentage of the population that would be consistent with this mixed stain in the Bronco, all that is done is that one lists all of the possible genotypes that one could have that would be consistent with that stain, computes the frequency, or adds up the frequency of each of those genotypes in each of the relevant populations, and sums them. And so we find that among Caucasians, 45.4% of Caucasians would match stain 29, 59.2% of African Americans, 48.8% of Hispanics would be included in the stain. And the percentage excluded would be the complement, simply taking these numbers and subtracting them from 1. This is what the jury needs to know in order to evaluate, for example, the fact that Nicole Brown Simpson's genotypes match the stain. These statistics are not what the prosecution is offering. They're offering conditional probabilities. Even if they don't frame them as a ratio of conditional probabilities, they are still conditional probabilities. That is, the probability of one event conditioned on a set of assumptions. What Dr. Cotton discussed was the probability of a pair of people giving certain results under certain assumptions. Now, the problem is the assumptions. The conditionals that Dr. Weir computed, for example, were all conditioned on the assumption that the number of contributors to the mixed stains was 2 individuals and only 2, and that somehow we knew that. Now, that might be an appropriate statistic in a case where we know the number of potential contributors to the stain. For example, a rape case where a woman says that she was raped by 2 men. But in a case like this, where we don't know the number of contributors, it is without foundation and irrelevant, prejudicial, and completely inappropriate to allow them to present statistics premised on certain assumptions when they cannot demonstrate those assumptions are true. The arguments become circular. In order to prove that the prosecution's theory of the case is correct, they offer statistics that are premised on the assumption that the prosecution's theory of the case is correct, and we go around and around in a logical merry-go-round. And that is why they're able to come up with numbers like 1 in 100 or 1 in 50, when the NRC numbers are 45%, 59%, 48%. So, this is
this is not appropriate. It doesn't comply with the court's order. It's not even consistent with their own chart. Their own chart, when they list numbers, is headed frequency. They're not offering frequencies. They're offering these complex conditional probabilities premised on sets of assumptions which are going to be controversial and which I think may not match the facts of this case. For example, if the prosecution's theory of the case is correct, the number of contributors to the steering wheel stain has to be at least 3. And yet, the statistics they're offering on that are probabilities premised on the notion that there are only 2 contributors. And the statistics ask, what's the probability that by randomly choosing 2 and only 2 people, you would produce the exact results that we see here? That's simply not relevant to the facts of this case.
Mr. Clark?
Yes. With regard to, first of all, Mr. Thompson's characterization is wrong as to the prosecution's theory that there's 3 donors on the steering wheel. All that's been reported by Dr. Cotton thus far is that there are types from which 2 individuals cannot be excluded, and there's another allele. That is not inconsistent with 2 contributors. We know there's at least 2 because there's a mixture. It may very well be only 2. But
No, I'm more interested not so much in the theory of the prosecution's case, but in the method in reaching this calculation in the first place. Have you had the opportunity to review the proposal by Professor Thompson with Dr. Cotton? Because this appears to be the aggregation that's recommended at page 59 of the NRC report.
Just very briefly, if I could, I'd like to speak with her a little bit more.
All right, when do you anticipate hitting this point in your...
That's flexible with the court's direction. If cross-examination is finished and then I can conduct my redirect, which at this point is not substantial, then perhaps, I see a smile on the court's face, then perhaps we could address this issue once Dr. Cotton and I have had a chance to discuss it.
All right, let's do that. All right, we've framed the issues. I think counsel should have the opportunity to go over with Dr. Cotton what these numbers are. Professor Thompson, do you have a similar calculation for the other stain?
I don't have it right now, Your Honor. I'd be happy to discuss with Dr. Cotton how we think that should be approached.
All right.
For that one, we need some additional data, which they have access to and we do not.
Okay. All right, then I propose that we proceed with the jury, that probably what will occur is Dr. Cotton and Mr. Clark will have the opportunity to confer over the lunch hour. And let's start with the jury now.
Your Honor, if I may, could I ask that Dr. Weir's report be marked as an exhibit for the court's purposes only?
Yeah, I'd like to read it over the lunch hour as well. All right, Deputy Magnier, let's have the jurors, please. Members of our jury panel, good morning, ladies and gentlemen. I understand we enjoyed our weekend activities. I understand one of us was unusually lucky. All right, Dr. Cotton, would you resume the witness stand, please? All right, good morning again, Dr. Cotton.
Good morning.
You reminded, ma'am, you were still under oath, and Mr. Neufeld.
Good morning, ladies and gentlemen. And congratulations, sir. Good morning, Dr. Cotton.
Good morning, Mr. Neufeld.
Now, what I'd like to do, Dr. Cotton, is return to item 29 briefly, which was where we left off on Friday morning. On direct examination, you had testified that the prosecutor's board was not correct because it failed to include Nicole Brown Simpson as a potential contributor to the mixed blood stain on the steering wheel. Is that correct?
That's correct.
And that's why you wrote in the name Brown?
Yes.
All right, do we need to prop that up so the jury can see what we're talking about here?
Yeah. And Dr. Cotton, on Friday during cross-examination, you admitted that the number 4 allele reflects the presence of a potential third person into that mixture. Is that correct?
Or will?
The 4 allele, if you assume that there are 3 people, the 4 allele is the third person. Alternatively, the 4 allele could just be a second person.
Well, isn't that true in fact with every... I'm sorry.
You can't tell from this data whether there's 2 or 3 people there.
In fact, in any instance where you have more than 2 alleles, let's say you have 3 or 4 alleles present, you can't tell whether it's a mixture of 2 people or more than 2 people, correct?
That's right.
Could be 3 people, right?
Could be.
Could be 4 people.
It could be.
Right. But if we're now simply referring to the column on that board, the second to the last column says not excluded, you'd agree, I think you've already said that Mr. Simpson cannot be excluded, correct?
That's right.
And I think you'd also said that you'd agree that Nicole Brown Simpson cannot be excluded as well, correct?
That's right.
But you're also saying that you can't exclude some other person whose identity is unknown. Isn't that correct, who possesses that 4 allele?
That's right.
So what I'd like you to do, Dr. Cotton, is to add, if you would, under the category that says not excluded, this additional card that
Let me
says
see
third
counsel,
person.
let me see counsel with sidebar, please, with the recorder. No, let's proceed. Mr. Newfield.
Thank you. Dr. Cotton, given the observed alleles on item 29, the mixed blood stain on the steering wheel, there's a category here called not excluded. You see that?
Yes.
Okay.
I'm sorry, Your Honor, may I walk through so that I can see this chart?
And the alleles observed again on sample 29 are 1.1, correct?
Yes.
1.2, correct?
Yes.
And finally the 4.
Yes.
And if we were able to make a separate column called not excluded, you would agree, Dr. Cotton, that Mr. Simpson could not be excluded as a contributor to this mixture. Is that correct?
That's right.
So I'm going to add his name into the column of people who cannot be excluded. And would you agree that given the alleles in this mixture, that Nicole Brown Simpson cannot be excluded?
That's right. I agree.
So I'm going to add her name to the column of people who can't be excluded. Is that consistent with your testimony?
Yes.
And would you agree, Dr. Cotton, that given the presence of the 4 allele, that anyone else who has a genotype, the DQ alpha, of either 4,4, 4,1.1, or 4,1.2 also cannot be excluded?
Yes, I do.
So may I
You're
add-
correct.
So may I add that collective person, if you will, as a third category under not excluded?
Yes, that would be another group of people that wouldn't be excluded.
Thank you. And is it consistent with your testimony if I simply describe this person as someone of either type 4,4 or 4,1.1 or 4,1.2? Is that
Yes.
correct?
Yes.
So by your testimony and your observations of this DQ alpha type, then there would be these 3 different listings under the not excluded column. Is that correct?
That's the 3 different listings you get. If you're assuming 3 contributors, you can break it down in that manner.
Oh, I'm not assuming anything.
I'm sorry,
I'm
can you
sorry.
finish your answer, please?
Yes.
Please do.
you could simply also make a list of all the possible genotypes that could be in there, and it would include the ones you've listed there, including the one from Mr. Simpson and the one for Nicole Brown.
In your
Nice. Thanks for finishing that answer. You finished out the day. Look how tired she looks right now. She's ready for us to finish the day. She's like, this is enough for one day. I wish two things. I wish that their testimony only lasted 2 hours a day like we're playing them, and they spent the exact same number of days on the stand. So like, so they only, like, we have her on the stand for like 30 days, but she was only really there for 10 because we're breaking it down. I wish that her testimony was only 2 hours every day for 10 days and not the 30. But that's not what happened. You can't go back in time. Whew. All right, guys. In 4 hours, I think, I'm going to be doing the Supreme Court live stream of Ralph Menzies, so I hope to see you there. If not, I'll see you again real soon. Okay? You guys have a great day. Thanks for coming out. Bye, guys.